Akinsanya v. Garland out of the First Circuit on January 10th. And this one was litigated, or at least ACLU New Hampshire was involved, as was Benjamin Osorio. So those two, Sang-Yup Kim and ACLU New Hampshire and Benjamin Osorio, they really are making really good law in the First Circuit for non-citizens, particularly in the Convention Against Torture context. And that's what this is about. Mr. Akinsanya was a police officer in Nigeria who was put to the north and went against Boko Haram, and then Boko Haram started doing things against him and his family and all this stuff. And then, he came to America, did a bad crime, and so only cat protection is on the table. And it is no secret, I think it is generally understood that the Nigerian government is not in league with Boko Haram. I mean, they're trying to do some stuff. I mean, some elements of the Nigerian government might be, but it's not. They are fighting Boko Haram, at least at points. I'm no expert on Nigeria.
Mm-hmm.
But Convention Against Torture requires a showing that the government will acquiesce or consent to the torture you fear. And what does that mean? And this is why this is so important. The First Circuit said that in order to deny a Convention Against Torture claim, an immigration judge must first describe and list out what the foreign government's duty to intervene is in that country. So as I read it, an immigration judge needs to look at a country and decide what specific duty this government, considering all things with this government, has towards people, in this case, Nigeria, towards people who are scared of Boko Haram. And then, only then can the immigration judge consider whether the steps taken, if any, satisfy that duty. A two-step process. And that is a big deal, because with Convention Against Torture Protection denials, it is often the case that an immigration judge and the BIA will say, well, the government has taken some action, they're fighting the gangs, they're doing this, they did this in 2023, they were not going to consent or acquiesce, they're fighting, and just the fact that they don't have enough resources to be successful doesn't mean that they're consenting or acquiescing. But that is not the law in the First Circuit, at least after this decision. Quote, a no acquiescence finding cannot rest solely on the fact that the government has taken some responsive action to combat private violence. There have to, the agency, quote, the agency must explain why the government's steps, though inadequate or ineffectual, nevertheless satisfy its duty to intervene, end quote. So that is a bit of a seismic shift. Consent or acquiescence focus is really about whether the government has satisfied their duty to intervene and protect their residents. That's a big deal. It's kind of coming from United Nations regulations or laws or however they work. And so check this out in the First Circuit and in other circuits. Try to spread it to your circuit because it's a big deal and it's a big protection for Convention Against Torture applicants.